Talk through 25 tips. You all have handouts. 25 tips to starting and running your dental practice. How many people here already have a dental practice in place or associates? A number. Some of you are thinking about starting a dental practice or associates. It's a lot of fun to operate and have your own dental practice. And the one thing I really admire about dentists is how they're all able to kind of have their own, in a sense, mom and pop shop and run their own practice. And it's a pretty exciting thing for a dentist to be able to do that. It's a type of profession that really enables that and lets you kind of be your own boss, which is really a wonderful thing. I've come up with, after representing a whole bunch of dentists, come up with 25 tips regarding running a dental practice, and I hope to share those with you. A quick dental story, because heck, I never get to talk to a bunch of dentists. Yeah, that'd be great as it works. This is like American Idol. Now I'm really excited. So one thing that I wanted to share with you is that I had braces for 4 years. I have 3 older sisters, and my 3 sisters each had braces. My parents didn't have a whole lot of money, but they really believed that we should all have straight teeth in order to be professionals, hopefully, in our future life. So I was 4th in line, and my 3 sisters each got braces and each got them off. I got mine on. My older sister still had hers on. She got hers off. And year after year, month after month, I'd get my braces adjusted. After a while, I was a pretty bright kid. I noticed my teeth were pretty straight. And I said to the dentist, you know, when am I getting these off? He said, maybe next month. So I would show up my $20 check, and next month would show up and show up and show up. Another year goes by, I'm in my 4th year of having braces. And finally, I got my braces off. I was 16 years old. I was the oldest kid in my class to get the braces off. So I was telling my sisters this story only a couple of years ago. I'm 47. A couple of years ago, I'm telling my sisters, hey, you know, why did you guys have your braces for 2 years? And I had to have my braces for 4. I just didn't get it. You know, we all have the same kind of teeth. And they all started laughing. And they said, well, you know what happened? I said, no. Well, Mom and Dad couldn't afford to pay for the braces, so you were the collateral. You know, waiting to pay for, you had to be paid up in full in order to get my braces off. So that's the problem of being the 4th child and having to deal with an orthodontist. So it's with that I should figure that I was the kind of person who should be protecting my rights, and maybe being a lawyer was a good idea, because I was collateral at a very young age. But when you're operating running a business, and this is really with any business, first thing you got to do is choose a name. And you got to choose a name that's not like anybody else's name. Dentists are particular. Sometimes you are required by state law to only choose the name that's your name. That's where you're restricted. But some states, most states, will allow you to be a little more creative and choose a name. So the first thing you do is choose a name, and also you may want to reserve your name with the Secretary of State. If you're thinking of a good name that you want to use, you can reserve that name with the Secretary of State. It doesn't cost a lot of money, but you can reserve it. You can't use a name that anyone else has, so that's an automatic restriction. So I don't know what happens, to be honest, if your name is John Smith and you're John Smith DDS is another one. I think you may have to do John Smith 1 DDS, but I can't imagine it comes up very often. So my first tip for running a business, obviously you have to have a name. It's funny, a lot of clients call me and they'll say, hey, I want to start a business. I want to start a dental business. And I'll say, well, what name do you have? And they're like, oh, can I get back to you on that? And that's actually the hardest thing to do, but it's one of your first things you have to come up with. Tip number 2. Consider trademarking your name. If you're not restricted in the type of name you can use, a name has goodwill, and you can trademark a name. It could also be trademarking a brand. So if by corporate law or by regulatory law, you're required to use your personal name and your degree as the corporate name, you could also brand a name. You know, Terrific Dental, for instance. Well, the way you brand a name is by working with the USPTO, the Patent and Trademark Office, and you can even see if a name is available or already taken by going on USPTO.gov. And there's a search function where you can check on the trademark to see if somebody else already has that name. So if you want to go, also an important thing to do is make sure a domain name is available, because it's great to have a website, and you want to have a that's available on a website. So a domain name, a .com, not a .net, a .com availability would be really great. Tip number 3. The next is choosing your form of entity, and this is where lots of folks get lost, and certainly where you need an attorney. If you're on your own, you could just have a sole proprietorship. You don't have a partner or have another. You could have a sole proprietorship. The problem with a sole proprietorship is you don't get liability protection. You know, for dentists, what's the true liability though? The true liability is you mess up somebody's teeth or something, you screw them up. And for that we have insurance. There's no entity that's going to get you liability protection on what would be arguably a negligence action. But you are signing agreements, you're signing contracts, you're entering into leases, different kinds of contracts. You probably do want an entity, some kind of liability protection for that reason alone, despite the fact that your main liability is doctor to patient. So there's sole proprietorship and there's a general partnership as well. The general partnership is when 2 people get together. It's basically 2 sole proprietors get together, and that creates a general partnership. Again, you don't have a liability protection just by doing that. You've agreed to share in your profits and losses, so you've created a partnership. But besides that, you have not gotten yourself liability protection. To get liability protection, you have to do something. You have to file something with the Secretary of State, and that something is either a charter for a corporation or a certificate of organization for a limited liability partnership, company, or if you're a partnership, you could also be an LLP, limited liability partnership, and file a certificate for that. So in all those cases, you have to do something, and it's that doing something, deciding what kind of entity you want to be, is what's the analysis or what's important. Let's just go through those real quick. There's a corporation, which is called a C corporation, and there's a corporation called an S corporation. Do folks know the difference in those? There is a key difference. One, you get taxed twice, and the other you get taxed once. Most dental offices would be an S corporation. They would almost never be a C corporation, and we'll go through the limits on that. But another great choice for a dental office would be a limited liability company, because the rules are a lot easier. So we'll go through the different kinds. A C corporation, you would file a certificate of organization, or a certificate of articles of organization, depends on what the state wants to call it, or articles of organization with the Secretary of State, and that creates you. You're now a corporation. But the key is now you've got to follow the corporate rules. You need bylaws, you need officers, you need directors, you need a board of directors. This could all be you. You could play all the same role. But it's important to follow these corporate niceties, these formalities, these rules. If you don't, there's a concept called piercing the corporate veil. Anyone ever hear the concept pierce the corporate veil? That's when you have a corporation, but you're not operating it like one. You're commingling. Commingling sounds like a nasty word, but you're mixing and matching your personal assets with your corporate assets. You're not keeping straight and clean corporate books. You're not having annual meetings, or at least papering the annual meetings. Everything's all mixed and matched. And when you do that for a corporation, you actually are not treating your corporation as a separate person. When you do that, you don't get the liability protection that you were hoping to get when you were forming the corporation in the first place. Limited liability companies are a little bit different. You could arguably pierce the corporate veil for a limited liability company, but there are so few rules. There's no board of directors, there's no president, there's no annual meeting. Because of that, it's other than kind of commingling your bank accounts, it's pretty hard to actually pierce the corporate veil for a limited liability company. And that's why a lot of people choose an LLC over a corporation. So management is much easier. You don't have to have a LLC or a corporation. The other choice is a limited liability partnership. And that's a type of partnership that that files with the state to get liability protection. Let's talk a little bit on the next slide about the S corporation, because that has the most rules. An S corporation, you know, for dentists, it would be hard to believe that you'd have 100 shareholders, but that's one of the restrictions. Also, another restriction is you can only have common stock. You can't do preferred stock. And say you were borrowing money from somebody and said, hey, I'll give you 20% going forward, and you get a liquidation preference. You know, if I ever sell this, you get your money back. Well, you can't do that with an S corporation. It's very restricted. Also, you cannot be you need to be a resident alien or a U.S. citizen. So you're restricted. None of these rules are in place for a limited liability company. So it's actually a much better choice when it comes to these types of rules. Let's talk about taxes, because that's one of the main considerations in the next slide. Taxes are a main consideration for choosing what kind of entity you want to be for your dental practice. A sole proprietor, for instance, does not have a separate tax return. Everything is just filed on your Schedule C on your personal tax return, so that's the easiest. So if you have QuickBooks, for instance, you just give your QuickBooks over to your accountant, and they'll do your Schedule C for you, and it's pretty easy. A general partnership, even if you have not filed anything, if you basically sharing in profits and losses with one or more other people, that triggers a partnership, whether you filed something or not. And so when you're in that case, you have to file a K-1 tax return. And they're fairly complicated. The tax return gets prepared, and then however the profits all get distributed, get allocated to the owners. So say you have two owners, 50-50, and you have a general partnership. Whether you decide to reinvest those profits or income back into the company, in other words, you don't take it, but you got to pay taxes on 100% of those profits. And so there comes a complication. Normally you would want to, if you've taken a salary and there's profits after that, you would want to at least distribute 35 to 40% of all leftover profits and require yourselves to do that in order to pay your taxes. Otherwise, you'll end up actually owing more taxes than you've received income for a C Corp, the tax is as follows. The corporation gets taxed at about a 25% level, and then when you upstream the income, you can take a salary, but when you upstream any income, there's a second tax, the dividend tax, 15 or 20%. So it lands up being it's the double tax, but it's not double in amount, but it is a higher tax to have a C Corp with a dividend as opposed to an S Corp with a one hit tax, which is basically your compensation tax. Let me mention a word called a professional corporation. Has anyone ever heard of a PC? Well, a PC doesn't sound like a C Corp or an S Corp. In fact, it's both of those things. A PC is a type of corporation that's specific to professionals, whether it's dentists, doctors, nurses. Some states require you to form a PC, which means you can't do the LLC, you can't do a limited liability company. But that does not restrict you from S corporation election. S corporation is a tax concept, it's not a corporate concept. So every corporation starts out as a C corporation. It's only when you file something with the IRS that you become an S corporation. Does that make sense to everybody? Tip number 5, the next slide, is every entity, partnership, other than a sole proprietorship, every partnership, every limited liability company, just about every corporation needs its own EIN, Employee Identification Number. Why? Every company is its own person. So the EIN is like the Social Security number for an entity. It's what you file your tax return with. It's usually what you open your bank account with for information purposes. And it's It's the number that are on an employee payroll. If you fail to get an EIN, for instance, if for some reason you're not required to get one, you'll end up using your Social Security number for these purposes, and most people don't want to share the Social Security number, so they get an EIN. How does one get an EIN? You get it just simply by, it's done actually online now, and it used to be, it took forever to get one. Now you could pretty much go on IRS website and you get the EIN number by just following a quick Q&A kind of fact kind of survey, and you'll get instantly your EIN. Usually your accountant or lawyer though will get an EIN for you. It's just more important to know that you have to have one in order to run your business. Limited liability companies, if you're the only owner, you're technically not required to get an EIN, because a single member, only owner, limited liability company does it just like a sole proprietorship. They're taxed just like a sole proprietorship on their Schedule C. So it's very easy for tax purposes to have a single member limited liability company. But people get EINs anyway because they usually have employees, they have bank accounts, and they prefer to not share the Social Security number for those purposes. Tip number 6, well, how do you create an S corporation? What is this tax election? There's a form that you file with the IRS called Form 2553, and it makes you basically sign your life away. You have to sign in about 4 places to say that you have this corporation, you own this corporation. The key talking point, though, is that this filing, this election, must be made promptly. I say next day. It's actually 75 days. But as you know in life, if you have 75 days, you'll probably wait till the 75th day. So it's best to do it the next day. And whenever I form an S corporation for a client, I always form, and it's going to be an S corporation, we make that election. I always make sure we file the same day or the next day, and by no means wait the 75 days. There is a kind of plea for mercy if you fail to file with the 75 days, but then you're at the mercy of the IRS deciding whether you have a good excuse for failing to file timely. If you do not file the S corporation election within enough time, you become a C corporation. You are a C corporation, so you have that double tax. So it's very important that if you're choosing to be a corporation, that the S election gets filed. This is something that strangely falls through the cracks, maybe sometimes between the lawyers and the accountants. But often what really happens is it's become a little too easy for individuals, non-lawyers, to just go online and create a corporation thinking this looks easy, I could do this, or to buy a kit for $50 and I know what I'm doing. And so they do that, but then they don't file the S election and really screw themselves up from a tax standpoint. So if you're interested in practicing law as a side job, at the very least file the S election. Next slide is tip 7. The reason why we form limited liability companies or corporations is to get liability protection. But as we know, that cannot protect you for everything. For professionals like you, you have to get professional liability insurance. But you could get insurance for other purposes, and that kind of goes hand in hand with any company formations to make sure you get the insurance as well. Obviously, if somebody gets injured by slipping on the rug, the torn rug, or for instance, you'll want insurance for that. There's another way to make sure you have insurance, and that's called a homestead election. It's not really insurance, but what it does is it protects your home from liability. Anybody should make sure they have a homestead protection, homestead election if they own a house. Every state has its own rules regarding this, but generally you're looking at a $500,000 or so protection on your home. Also, if you're married and have a spouse and you own the property by entirety, yet, which is just a deed on your deed, it says husband, wife, husband, wife, owned by entirety, tenants by entirety, then in that ownership will prevent someone who has just a claim against one owner from going after the property. So tenants by entirety ownership is important on your deed, plus a homestead homestead election, and that's the best way to protect your house from potential liability. Tip number 8, we discussed that a regulator may require that you're a professional corporation, that you have a professional corporation. As I said, though, it's important to know that a professional corporation is a C corporation or an S corporation. It's just a professional who owns a corporation. Generally, another restriction on that is that only other dentists can own it with you. And sometimes you cannot own it with for instance, only dentists can own it. So lots of folks want to own a company, a business with their spouse, for instance. If your spouse isn't a dentist, you may be restricted from doing that if you're required to have a professional corporation. Sometimes you want to have an investor. The investor may be restricted from owning a professional corporation, and that's a state-by-state rule requirement. Tip number 9, when you own a company, you want to make sure that you sign documents in the appropriate way. Lots of folks will own a company and then kind of forget that they own it and actually just sign their names to everything. Well, when you sign your name to everything, that's just you signing your name to everything, which means you have not gotten the liability protection. So if you sign a contract, for instance, and it's just your name, you've signed that contract personally, which means if for some reason there's a lawsuit or a breach related to that contract and someone sues you, they will sue you personally. The whole idea of having liability protection and having a corporation and a business entity is to protect yourself from liability. Well, it starts with signing on behalf of the entity, not as yourself. And so here are some examples. For instance, for a corporation, you should always have the name of the corporation on the top line, a by, word by, with a colon, and underneath it, your name and your title. For instance, you know, John Smith, DDS, President. That's how you would want to sign that. It's not a whole lot different for a limited liability. For instance, limited liability company, you would have LLC by the managing member. Sometimes your manager is another entity, not in your case, but it would be Great Success LLC by John Smith, DDS, manager, for example. Same thing with a general partnership or limited liability partnership. So it's very important to sign your name properly on any contract and to not be loose. Lots of times you're presented with a contract and they'll just populate things for you. Well, fix it. Over that, put the name of your entity, put the word by, your name and title below, and then sign.
Yeah, sure.
Tip number 10 is entering into a lease. Your location is the most important thing. Dental patients love their dentist, but they don't like to travel very far. They're kind of fickle that way. So you want to make sure that you've found a location, but also that you have the ability to renew that location, renew that lease if the business takes off, because your location is part of your goodwill. So most leases, some leases just go year to year. You're really at the risk and the whims of the landlord or the owner if you've done that and you signed a lease that way. What you really want to do is secure a lease. You want to have the most options for yourself, but secure the lease where you can renew the lease every 5 years. There may be an escalation clause on the rent where you have to pay a little more based on inflation, but you want to make sure you got a 5-year renewal, so that you can make a career out of this location. And also for resale value, you want to make sure that 5-year renewal is in there, because if you were to sell this business, again, it's all about the location, because the patients won't go very far if you end up having to relocate. So making sure that your lease has renewal options in it, as opposed to these kind of 30-day or 1-year lease, is a very, very important to operating your business, and something that a lot of folks miss. Tip number 11, when you're looking at a location, a lot of dental practices are kind of funny. Veterinary practices, sometimes they're houses or they're condos. And you've got to make sure that location is actually zoned for the kind of things you want to do. You don't want to buy this practice, buy this location, and then realize you're not allowed to do it. This comes up a lot actually with condos because condo bylaws and condo associations restrict the use. And if for some reason your use is restricted or you haven't gotten permission, you could be locked out. You could actually buy a practice or sign a lease or move in only to find out later that the condo board has decided they don't really want you there. Or maybe they were okay with you there, but they didn't like all the patients coming in and decided after the fact, well, do we have a reason to kick you out? They'll look at their condo bylaws and find a way to kick you out. So you want to be very careful that when you're looking at a location that you are, make sure somebody has reviewed the condo bylaws, the restrictions, and the zoning, the local zoning as well. Tip number 12, signage. You know, like I can imagine a great dentist sign that's as bright as the convention center where it just kind of blinds you and the teeth are smiling and it's white. Well, a lot of local jurisdictions restrict not only the size of a sign, but also now they also restrict the brightness. Because of all the LED lighting and the way it's so bright, they'll restrict the brightness of the signage. So when ordering a sign, putting up a sign, think clearly about the size, but also the brightness. There's also one other thing to think about is, again, the name. Remember we talked about trademarking a name? You want to make sure that the name is available. You don't want to order a sign, pay all this money for a sign, and realize someone's going to write you and say, you can't have that sign anymore because that's my name, and I just saw it up there, and you got to take it down. Tip number 13 is hiring associates and entering into associate agreements. I think it's very important that if you hire an associate, you have an associate agreement. And there are different components to what an associate agreement should provide. The first is you want to make sure the associate is an at-will employee, not an employee for a term. And that means generally that you'd be able to let the associate go if for some reason you weren't happy with the associate or you weren't able to fill the plate or the associate wasn't, patients didn't seem to like the associate or vice versa. It just wasn't working out. I mean, typically from just a good faith standpoint, you want to provide for a 90-day termination unless there was some real reason for cause termination. But that is an at-will employee, which means you have a right to terminate the associate at any time with, as provided in the agreement, 90 days notice. But it's very important that the associate agreement says at-will employee. Next is to cover things like compensation and vacation and sick days. Compensation for associates tend to be in the 30 to 40% range on revenue in. It's usually adjusted revenue. You'll usually see the revenue being adjusted based on the lab fees. So say there's and sometimes I see a tiering, for instance. A recent one I saw, for instance, was the first $100,000 less lab fees. So say, I don't know what your percentage of lab fees would be, but say the revenue was 110 and the lab fees were 20, that left you at 90. Well, that 90,000 would be a 30% commission or pay. And then between 100 and 150 would get tiered and be at 35%. And then over 150 with 40%, all adjusted for the lab fees. Because an associate has to start up and there's no money coming in, often there's either a probationary period where there's a money paid up front, or like a signing bonus, or a draw ahead of the lab fees, or there's draws all the way down and then you adjust it either quarterly or annually based on actual revenue in. But there's this concept in most associate agreements that I see, which is typically 35%, but I've seen the range of 30 to 40% based on compensation. You need to be able to get out of associate agreements, and that's a two-way street. So you should have a termination provision as well. So just think, if you didn't have an associate agreement, how difficult it could be to figure all these things out. It's much better to have a written agreement in place. Tip number 14 is also a important component to hiring an associate. which is a non-compete and non-solicitation. A lot of states have restrictions on whether you can have this or not. I can speak for Massachusetts, for instance, permits non-compete, non-solicitation for dentists, but does not for doctors and lawyers. So obviously the dental lobby wasn't looking out for you guys, but they were looking out. The lawyers looked out for themselves, and somehow the doctors got taken care of. Which means, for better or worse, and in a way it's good. Accountants, for instance, have non-competes. They have to kind of buy their way out of practices. Which means, from a non-compete, you could restrict somebody, if it's reasonable, from practicing dentistry, an associate from practicing dentistry within a certain geographical region of your own office. What I like to do in order to be as fair as possible when I'm constructing these is to actually pick the city or town and maybe the bordering towns, as opposed to, although I see more often, for instance, a 5 mile. So when you're doing 5 miles, you say, for instance, you take your office and you go 5 miles in any direction. That's actually a 10-mile spread, you know, as the crow flies. So sometimes that's a bit restrictive. For instance, also, if you're in, for instance, the city of Boston, you're not going to get away with 5 miles. You're going to get away with a much smaller range or blocks because there's so much more population. So these are the kinds of considerations that you have when you have a non-compete. But does anyone know the difference between a non-compete and a non-solicitation? No one's brave enough. The non-solicitation is actually just as important as non-compete, and for some reason folks don't talk about it, and sometimes it's completely missing from agreements. A non-solicitation means that I don't care where you're working, you can't come after my clients, you can't come after my patients. That's important, and often there's a carve-out, friends and family that the associate brought in. But the key to a practice, any practice, is retaining the patients. You want to get them there. So it's very important to have not just a non-compete, a geographical restriction from practicing, but a non-solicitation. Tip number 15, know the difference between an employee and an independent contractor. You do not have to pay payroll taxes for an independent contractor, and so it sounds really exciting to have an independent contractor say, well, hey, you show up, I don't have to pay payroll taxes, I'm just renting this chair. That's the concept. Well, guess what? If they're only showing up at your office, and they're showing up 3 or 4 times a day, and they're using all your tools, well, I don't care what you're calling them, they're an employee. And the state will actually come after you and say you're not paying your payroll taxes appropriately. Also, the employee/contractor may have a cause of action against you. So it's very important not just to say, I'm going to call you an independent contractor, I'm renting a desk because I say it's so, and that's because that's what our agreement says. But the facts have to measure up to that decision. Now, if the same dentist is working at your office, has their own website, has their own patients, goes to other dental practices, rents a chair on Monday, rents a chair on Tuesday, well, now you have a fairly good argument that you have an independent contractor on your hands and not an employee. But it's very important to know the difference between those two. Tip number 16 are my plug to the grants. Employee benefits and payroll service. You will never get employee benefits correct. I promise you that. I'm an attorney and I cannot get employee benefits correct. You need a service for that. You know, rely on the service, whatever plans you want to have in place, 401k, the SEP plans, IRA plans. Just make sure you use a service. They'll get it right for you and you won't get it right for yourself. But it's key to making sure your benefits are set up properly. The laws on discrimination, non-discrimination laws are very difficult, and it's important to get that right. On the counterpart, payroll services. It's unusual to try to do payroll on your own, although some people do try because they're trying to save on money. But an ADP kind of company is really the best way to go for a payroll service, and to not try to make sure they're doing the deductions correctly, the W-2, all that kind of information properly. Tip number 17. Well, you don't have to start a practice from scratch. You can actually buy into a practice or buy a practice. And that's yet another way to start a practice. And we see lots of young dentists or dentists who are associates for retiring dentists or other dentists who want to move on, actually buying the practice. And the key to buying a practice is either through an asset purchase or a stock purchase. An asset purchase means that you're buying all of the assets of that practice, but none of the liabilities. That means you're getting the client files, the equipment, the name, the domain name, but it's in a company, an organization, an entity that you formed yourself, and you're throwing the assets into them. The benefit is there's no liability. For your type of business, the true liability, as I said, is really negligence, and there's usually insurance covering for it. But most people will still want to do an asset purchase for a dental practice. The flip side of an asset purchase is called a stock purchase. You may be called a membership interest purchase for a limited liability company. But a stock purchase or a membership interest purchase is actually buying the entity itself, which means you're taking all the liabilities, known or unknown, and they're now your liabilities. You own those liabilities just like you own the assets. I think you can see the value or the benefit of doing an asset purchase versus a stock purchase. Folks try to save money. And they say, hey, I'll buy your business. Sure, you want to sell my business? Sure. And they find an agreement online. It just happens to be a stock purchase agreement. It may be for an LLC, but it's all messed up. But at any rate, it's a stock purchase or a membership interest purchase, and you're buying the liabilities. You may not know that you even had a choice not to buy these liabilities, but it's a clear thing that you should be protecting yourself for. Tip number 18. Use a CPA or valuation service to know what it is you're buying. Typically it's a multiple of revenue, and that's the value of a practice. I think Mark may give some guidance in the next session as to value of a practice, dental practice, maybe. He doesn't want to tell the answer. The answer may be because we don't know. But it's usually a multiple of revenue, and the value isn't as follows. I really need $1 million for my nest egg for me to retire and live on appropriately, and therefore the value of my business is $1 million. Well, it isn't that. There's a market for dental businesses just like any other business, and you got to pay the value. You want to pay the value, the fair value for that. So you don't want to get, just because you've always appreciated the dentist, that doesn't mean that the value is what that dentist says it is. Tip number 19 is called due diligence. That's a term that lawyers use a lot. I don't know if dentists have a counterpart for due diligence, but what it means is when you're looking at a practice, you want to make sure you kind of check it out. That means you need to look at the financial statements. You need to look at the books and records. You need to look at personnel files. Were there issues regarding personnel? Do you have contracts, associate contracts in place? Is their insurance coverage appropriate? What does the lease look like, the real estate lease? Do you have that renewal term in the lease? Due diligence is a key part to buying any practice and knowing what you're buying. Tip number 20, when buying a practice, there's a concept of work in progress, and it's, for some reason, the most difficult thing to get through is work in progress. Everyone's worried about work in progress. It's such a small part to doing a transaction or buying a business, but seems to become so important. And essentially all that means is if a procedure you're doing has stages, you want to put some kind of value on that procedure, and then following the closing, you want to make sure that that's adjusted one way or the other. So everyone gets their fair value for having to finish or complete the procedure. What could happen is a year later somebody complains about the procedure from a year ago. Usually a purchase agreement will have an adjustment for those kinds of scenarios. Tip number 21. There's that non-compete, non-solicitation again, but it's completely different. For an associate agreement, you are only permitted, basically, to restrict an employee for up to 1 year. That's your typical non-compete period. Sometimes a non-solicitation, you can go a little further than that, 2 years, 3 years maybe. But there's many, many laws protecting employees from non-competes, and in part, non-solicitations. Well, guess what? When you're selling a practice, your patients are part of the goodwill that you're selling. So your non-compete and your non-solicitation are much different and much broader for a person, for a dentist selling a practice than it is for an employee in any practice. You can get up to 5 years of a non-compete for selling a practice. And that's really important because you're buying the goodwill of that practice, so you want to make sure that you get as long a protection as possible so that dentist who has great relationships with all these patients can't come back into a territory and take those patients away from you. Because you paid for those relationships, it's very important that you protect yourself for that. Tip number 22. Patient confidentiality when transferring files. I am not a HIPAA specialist. We have a whole healthcare group, but it's very important to make sure that you appropriately protect files, secure private information. Massachusetts has very strict laws. California has very strict laws with respect to any information about anybody. And then on top of that, you have medical privacy laws, and you need to make sure that you're complying with all the HIPAA requirements. Tip number 23. Does anyone remember tip number 12? Tip number 23 is buying equipment versus leasing equipment. You should always do an analysis as to whether you should actually own this equipment or you should lease the equipment. You may get a different accounting treatment based on whether you own or lease. Sometimes you think you're going to get better accounting treatment, but it's treated as owned even though you're leasing. You want a service agreement with all your equipment. If you're buying, you want a clear warranty plus a service agreement. You really, really want to look at not just the equipment that you're buying, but how do I make sure it functions and continues to function as I want it to, and how do I return this? If equipment and technology goes stale over time, so you may not want to buy, you may want to lease, and that's an important analysis that you have to do. Tip number 24. We talked about personal liability, and there are certain areas where even if you formed a corporation or you formed a limited liability company, there are folks who are going to expect you to sign something personally. That happens a lot with large pieces of equipment. It happens a lot with real estate, the lease, although do your best to not do that. And it'll happen almost all the time with any personal loan that you get, not personal loan, business loan that you get, but it ends up being a personal loan because you're going to be asked to guarantee it. I would expect any bank financing, unless you're, I don't know who, you would have to expect to sign that personally. A landlord has flexibility. You should try to push back from a landlord on signing personally. When it comes to leases, often the lease broker is very sloppy, and you could just skip signing the blank line and it'll go through. You don't know how many times I've seen the paperwork without the personal signature on the bottom, and the lease company, so they kind of shrug their shoulders because they just never even looked at the paperwork. So do your best to actually not sign anything personally if you can get away with it. The whole idea of having a company is to protect your personal assets. So when you're signing something personally, you're unwinding that. Last but not least, tip number 25. Does anyone know what the word indemnification means? Indemnification? Yeah, 1, 2. Most people do not know what the word indemnification means, and I think we should teach that word to every 3rd grader or 4th grader, because it becomes the most important word in business when you're signing a contract. I indemnify you, you indemnify me, we indemnify you for this. It is essentially you saying, whether it's your business or you personally, that you're standing behind something. You're personally guaranteeing that this will be true. you're going to pay them if it isn't true. So watch out for the word indemnification. Look for instance, look for caps on indemnification. Lots of indemnity clauses say, yeah, I'm going to indemnify you, but only up to the amount of this agreement, but only up to the amount of $1,000 or $10,000. On the flip side, if you're the one indemnifying, you want to put a cap in there. I'll indemnify you, yeah, but sure, but only up to the amount of the benefit of this agreement, or $1,000, or $2,000, or $10,000. I can't tell you how many agreements I see where the agreement itself is very narrow, but the indemnification clause is very broad, and you've completely exposed your company to a lot of liability because of that. So that's my 25 tips. If you press me, I could probably come up with 25 more, but I'd bore you guys to tears. And does anyone have questions? I'd even give you the mic.
If an employee has inadvertently made some business expenses and they're personally or personal charge, do you recommend that the corporation reimburse the employee or attempts to pay those charges directly?
So the personal expense, employee put personal expenses, business expense on their personal. I would have the employee submit a. I would have a procedure in place to make sure that you had a form and a receipt so that your personal expenses or business expenses are put on that form. They fill it out, they sign it, you keep a record of that, and then you give the employee a check for the business expense. Some people do business credit cards. I really for employees, obviously those are scary because they don't necessarily have limits. The kid gets it or somebody steals it and all of a sudden you have this potential exposure. So you have to be very careful with trusting people with company credit cards. So some states, many states, have a restriction on who can own a dental practice. And it is true, as you decided, many states, if not all, I can't say I know all the states, require that only dentists can own a dental practice. If that's the case in your state, then that's the case. You cannot have an investor that also owns or a spouse that also owns your practice. The broader concept of an S corporation is you can have up to 100 shareholders. Well, that's a tax concept. You may have a dental regulatory restriction, which further restricts that, which says, hey guys, only dentists. And that's something that's part of your license required. Yep.
Most of the dentists hire you for a finite period of time to establish them or sell the practice, or do they kind of retain you over the years to do all their business stuff?
So, what do dentists usually do when they're hiring? What do they have in mind? Well, first, whenever you're trying to get hired, you almost want to say, well, how old are you? You know, it's kind of that reverse discrimination kind of thing. You can't hire based on age or gender, but you almost want to know, well, who's hiring me and what's their stage in life? What are their intentions with me? And these are fair questions because you want to know, are you just going to hang your hat here for a while, or is this going to be a permanent home? Am I possibly transitioning for this dentist? A lot has to do with the age of the dentist or how successful that dentist has been, or just whether they're ready to get out. And I think you just need to have a frank conversation as part of hiring is, what are your expectations? Are you hoping that I buy in after a certain period of time?
Hiring you as a lawyer.
Oh, hire me as a lawyer?
Not hiring associate.
Oh, sorry.
I think I've heard dentists who have a lawyer that they use.
Yeah.
So when they need to get stuff done, it's much easier. But most dentists I know don't have a lawyer that they
Yeah.
use. I was wondering how people hire you to sell a practice when they need a lawyer.
Yeah.
Are you retained?
Oh, okay. I love this question. How do lawyers get hired? You know, I planted you. I planted you. How do lawyers get hired? Well, just call. And lots of folks, it's not just dentists, although dentists are particularly bad at it, like to practice law on their own. and inevitably, 80% of the time, 40% of the time, it'll be fine. Nobody will notice a difference. But when there's a problem, everyone will scratch their head and say, God, why didn't we hire a lawyer in the first place? It really, dental practices are kind of funny. Buying and selling really isn't that expensive because it's a very simple, you're not talking about a ton of software and things have to be assigned. It's not that difficult to buy and sell a practice. And it's not that expensive to have a lawyer help you. But the way you hire a lawyer is both buyer and seller need their own lawyer, or at least one needs a lawyer, and you hope for the best for the other. And the lawyer is representing you, and they're presenting and creating and drafting the asset purchase agreement, and giving advice, negotiating that agreement, making sure it gets closed, but also trying to look out for you. What does this lease say? What is the zoning? Are there issues with the financials? Is it overpriced? That's the kind of thing. So usually a lawyer will ask for a retainer, have you sign an engagement letter, and then bill by the hour, and they'll usually give an estimate for what they think the cost of the sale will be. Any other questions? Yeah.
I wonder if you could speak to setting escort wages.
Escort wages, can they be low? Are you going to, I don't see Mark here. Can you set escort wages particularly low to avoid payroll taxes? Well, first, I don't know that works because in the end, if there's profit, that profit automatically gets allocated to the owner, and the owner has to pay compensation tax on the profit anyway. But what some people try to do is set their escort wages particularly low because what they're really trying to avoid is, I think, this gets a little out of my scale, the 1.5% and the 3%, some of the specific payroll taxes that are specific to, that somehow do not get into that compensation as a shareholder. There's a rule and there's a guideline, and the IRS knows when you're doing it. They know what a dentist kind of should be paid based on the value of the revenue of the practice, and it could be that if you play around too much, it would trigger an audit. So I think you have to be very careful with unrealistically setting compensation so low, because the IRS is obviously onto the trick, and it could be one of those red flags that automatically triggers an audit for your practice. Any other questions? Well, again, I'm Mike Refolo. I'm a partner at Mirick O'Connell, and if you ever needed help or even want a referral, I'd be happy to work with you. Thank you all.